संविधान ने अधिकार दिए नागरिकों को, तो संविधान प्रदत्त जो अधिकार हैं उसी की सुरक्षा के लिए बना है नागरिक सुरक्षा संहिता अधिनियम। महोदय, इसमें कुल 484 सेक्शन थे, 531 सेक्शन अब हुए हैं और 37 चैप्टर पहले थे, 39 चैप्टर अब कर दिए गए हैं। इसमें 39 सबसेक्शन क्लॉजेज, 40 प्रोविजोज, 4 एक्सप्लेनेशन जोड़े गए हैं और 177 सेक्शन को मॉडिफाई किया गया है। महोदय, इसी तरह से जो अंग्रेजों द्वारा पारित कानून था एविडेंस एक्ट 1872, वो कहलाएगा भारतीय साक्ष्य अधिनियम। उसमें 167 सेक्शन थे और महोदय अब उसमें 170 सेक्शन हैं, 2 सेक्शन, 6 सब सेक्शन और एक शेड्यूल उसमें ऐड किया गया है। अब महोदय मैं सबसे पहले आता हूं भारतीय न्याय संहिता। महोदय, अंग्रेजों ने जो कानून बनाया, सबसे पहले उन्होंने उन धाराओं को रखा जैसे सरकारी अधिकारियों से विवाद, उन्होंने जोड़ा कॉइन को गलत तरीके से बनाना, इस टाइप की चीजें उन्होंने जोड़ा। उनको जो सबसे बड़ा अपराध है मानव वध, महिलाओं और बच्चों के साथ व्यभिचार, वो उनके लिए प्रायोरिटी नहीं थी महोदय, इसलिए 302 जो है मानव वध, उसको स्थान मिला 302 पर, और व्यभिचार जो था, बलात्कार था, उसको मिला 376। महोदय, जो महोदय ये कानून आया न्याय संहिता, ये सबसे पहला चैप्टर जो है वो महिलाओं और बच्चों की सुरक्षा से संबंधित है। उनके विरुद्ध जो अपराध हो रहे हैं उसको रोकने और हम उसको न्याय देना कहेंगे, क्योंकि सजा तो अंग्रेजों की शब्दावली थी। इसमें जो लाया गया है एक शब्द गैंग रेप, अगर 18 साल से कम महिला बच्चे के साथ गैंग रेप होता है, इसमें फांसी तक की सजा का प्रावधान दिया गया महोदय। इसके अलावा अगर गैंग रेप होता है और किसी महिला जो 18 साल से ऊपर हैं, तो उसमें आजम कारावास और 20 साल तक की सजा है। महोदय, एक महत्वपूर्ण शब्द जोड़ा गया है आतंकवाद। हमें इस बात का अफसोस है कि हमारे अपोजिशन के मित्र यहां पर नहीं है। आतंकवाद आज ये खाली देश के नहीं, पूरे विश्व की समस्या है और हमारे प्रधानमंत्री जी विभिन्न मंचों से इसको हमेशा उठाते रहे हैं कि इस पर जीरो टॉलरेंस की नीति होनी चाहिए। महोदय, 1985 में बना था टाडा अधिनियम। यह था जब पंजाब में आतंकवाद फैल चुका था, हमारे एक प्रधानमंत्री जी की हत्या हो चुकी थी, और टाडा का हम लोगों ने, तब भी मैं सेवा में था, यंग एसपी, और हम लोगों ने इसका प्रयोग किया और उस समय टेररिज्म को रोकने में बहुत बड़ा ये फायदेमंद रहा। महोदय, ये टाडा 1985 में कांग्रेस ने विड्रॉ कर लिया, रिपील कर दिया, जब इसकी हमें जरूरत थी। क्या जरूरत थी? 90 में कश्मीरी पंडितों, सिखों, हिंदुओं पर अत्याचार हो रहा था, नरसंहार हो रहा था, पलायन हो रहा था, कश्मीर में आतंकवाद पीक पर था। तब कांग्रेस पार्टी ने 1995 में अपनी तुष्टीकरण की नीति के तहत इस कानून को वापस ले लिया टाडा। महोदय, उसके बाद आता है माननीय अटल बिहारी वाजपेयी जी होते प्रधानमंत्री। 2002 में पोटा लाया गया, प्रिवेंशन ऑफ टेररिज्म एक्ट। किस संबंध में लाया था महोदय? अभी हम लोगों ने 13 दिसंबर को शहीदों को दिया है, मैंने श्रद्धांजलि दिया है, जब पार्लियामेंट अटैक हुआ था और उन्होंने अपनी बलिदान देकर पार्लियामेंट की सुरक्षा किया था, सदस्यों की सुरक्षा किया था। उसके बाद जब लाया गया, ये हमारे विपक्षी उसको लाने के पक्ष में नहीं थे और राज्यसभा में वो बिल गिर गया था। उसके बाद ये तीसरा मौका था भारतीय संसद के इतिहास में, संसदीय इतिहास में, जब ज्वाइंट सेशन में राज्यसभा लोकसभा में पोटा पास हुआ, और पोटा पास हुआ। उसके बाद टेररिज्म पर रुकावट आई, आतंकवादियों में डर पैदा हुआ, लेकिन जैसे ही 2004 में मनमोहन सिंह जी के अंडर में सरकार आती है, वो पोटा वापस ले लिया गया महोदय। उसके बाद जो देश में आतंकवाद फैला महोदय, उसको बहुत ज्यादा कहने की जरूरत नहीं, लेकिन मैं कुछ चीजें मैं जरूर कहूंगा। एक हमारे कांग्रेसी मित्र अभी बैठे थे, अभी वो चले गए। 26/11 जब अटैक हुआ तो बॉम्बे गए और उन्होंने कहते रहे कि साहब ये तो पाकिस्तानियों द्वारा नहीं किया गया है, ये तो आरएसएस द्वारा किया गया है, बजरंग दल द्वारा किया गया है। महोदय, उन्होंने एक पुस्तक लिखाई अजीज बर्नी से, नाम था 26/11 आरएसएस की साजिश, और वो खुद गए दिल्ली में और बॉम्बे में उन्होंने उसका विमोचन किया। कई पुराने कांग्रेस नेता उन्होंने भी कहा, सबने कहा नहीं साहब इसमें हाथ नहीं है, जबकि कसाब जैसा आतंकवादी पकड़ा जा चुका था और उसे फांसी की सजा हुई। महोदय, जो देश में ब्लास्ट हुए, जिसमें यहाँ का दिल्ली में सरोजनी नगर, पहाड़गंज, बटला हाउस, यहाँ का हाई कोर्ट, जयपुर ब्लास्ट, अहमदाबाद ब्लास्ट, 26 जुलाई 2006 को बॉम्बे में ट्रेन ब्लास्ट, सीरियल ट्रेन ब्लास्ट, 209 मारे गए थे, और उसके अलावा ओपेरा हाउस ब्लास्ट, बंगलुरु में ब्लास्ट, हैदराबाद में गोकुल चाट, बुद्धा मंदिर ब्लास्ट, मोदी जी के रैली में पटना में ब्लास्ट 2013, यूपी के कचहरी ब्लास्ट, महोदय काशी में 3 ब्लास्ट। ये तमाम जो ब्लास्ट हुए, ये उसी समय ये यूपीए सरकार की देन थी, और दुखद ये था कि कानून समाप्त कर दिया गया था, और आतंकवाद रोकने के बजाय ये कांग्रेस पार्टी अपनी तुष्टीकरण के नीति में इसको एक भगवा आतंकवाद का एक शब्द दिया अपनी तुष्टीकरण के लिए, जिससे वो पावर में आ सकें। लेकिन आज पूरा देश देख रहा है कि आज कांग्रेस का पूरे देश से सफाया हो रहा है। महोदय, दूसरा मैं कहना चाहता हूं ऑर्गेनाइज क्राइम। महोदय, ये ऑर्गेनाइज क्राइम, ये तमाम माफियाज हैं, हर स्टेट में है, उनकी पैरेलल इकोनॉमी है, और उस पैरेलल इकोनॉमी के लिए, उसको क्रश करने के लिए, उनको कानून के कटघरे करने में कोई कानून नहीं था। कुछ जगह स्पेशल एक्ट थे, जैसे उत्तर प्रदेश में उत्तर प्रदेश गैंगस्टर एक्ट, महाराष्ट्र में मकोका, उसका इस्तेमाल हुआ, और उत्तर प्रदेश में योगी आदित्यनाथ के कार्यकाल में आप देख रहे होंगे जितने माफिया सब जेलों में हैं। इसके अलावा उनकी संपत्तियां हजारों करोड़ में हैं, उसको कन्फिस्केट किया गया है। और आज उसी का कारण है कि जब एक शांति व्यवस्था की स्थिति पैदा होती है आदर्श, और तब निवेश आता है। उत्तर प्रदेश में पिछले साल 36 लाख करोड़ का निवेश आया। आज भारत में निवेश ही निवेश है। महोदय, जब यहाँ आतंकवाद था, ब्लास्ट होते थे, तो विदेशों से एडवाइजरी जारी होती थी, भारत सुरक्षित देश नहीं है। और जब ऐसी स्थिति आती थी तो यहाँ विदेशी निवेश करने नहीं आता था, टूरिज्म नहीं आता था, हमारी टूरिज्म इंडस्ट्री थी बैठ गई थी। महोदय, आज मोदी जी के नेतृत्व में आतंकवाद पर, ऑर्गेनाइज क्राइम पर जीरो टॉलरेंस की नीति है, इसीलिए हमारी अर्थव्यवस्था पूरे दुनिया में ब्राइट स्पॉट है। आज हमारी ग्रोथ जो है 7.6% है महोदय। उसका सबसे बड़ा कारण है यहाँ आतंकवाद के प्रति जीरो टॉलरेंस और क्राइम के प्रति जीरो टॉलरेंस, उसकी व्यवस्था की गई है। अब महोदय, मैं बताना चाहूंगा अपनी महिलाओं के बारे में। एक अपराध बहुत होता है चेन स्नैचिंग, पर्स स्नैच कर लिया, चेन स्नैच कर लिया, और इसके लिए कोई स्पेसिफिक आईपीसी में धारा नहीं थी। और उसमें क्या होता था, कभी चोरी में लिख दिया, कभी वहां गए अच्छा खाली लिख कर दे दो। लेकिन अब उसके निदान के लिए, स्नैचिंग के लिए आईपीसी में एक अलग धारा लाई गई है। महोदय, ये स्वागत योग्य है। अब आता हूं मॉब लिंचिंग। मॉब लिंचिंग के बारे में हमारी विरोधी पार्टियां बहुत हल्ला करती हैं, और कहीं अगर वो बीजेपी शासित राज्य में हो गया तब तो उनका कोई जो है वो छत पर से चिल्लाते हैं, अरे यहाँ तक कि आदिवासी को नहीं, बैकवर्ड को वो दलित बना देते हैं। मुझे मालूम है एक केस में हुआ था, मेमुला केस, ऐसा हल्ला किया उन्होंने। तो ऐसी पार्टियां जो मॉब लिंचिंग के बारे में चिल्लाती तो बहुत थी, लेकिन कांग्रेस पार्टी रूल की कभी कोई कानून नहीं लाया। महोदय, मॉब लिंचिंग की जो घटनाएं हुई 1984, जब यहां सिखों पर अत्याचार हुए, खासकर दिल्ली में और प्रदेश में हुए, 3000 लोग मारे गए, तो क्या था? मॉब लिंचिंग था। उस पर ये नहीं बोलेंगे महोदय। और तो और इनके पार्टी के नेता शामिल थे, उनको कानून के कटघरे में भी महोदय इन्होंने खड़ा नहीं किया। इनके कार्यकाल में दंगे होते महोदय, बड़े बड़े दंगे हुए। मैं तो उत्तर प्रदेश कैडर का आईपीएस अफसर रहा हूं। वहां पर 1980 में मुरादाबाद दंगा, 87 में मेरठ दंगा, आसाम में नेली दंगा, दुनिया भर में दंगे फसाद होते थे, मॉब लिंचिंग, लेकिन इन्होंने कोई उसकी व्यवस्था नहीं की। कश्मीर में कहने की जरूरत नहीं है। और ये मॉब लिंचिंग पर कभी ये कानून नहीं लाए, क्योंकि ये हमेशा तुष्टीकरण की राजनीति करते हैं। और आज मैं गृह मंत्री जी का धन्यवाद करता हूं कि इन्होंने मॉब लिंचिंग जैसा एक कानून लाया। इसके बाद डेथ काज बाय नेग्लिजेंस एंड रैश ड्राइविंग। महोदय, अंग्रेजों के समय में कानून बना, धारा 304A। गाड़ियां उन्हीं के पास थी, बड़े बड़े जमींदारों राजाओं के पास थी। तो ये हुआ कि 2 को मार दो, 4 मर गए एक्सीडेंट में, सजा थाने से ही अवेलेबल था, 2 साल की सजा थी केवल। अब महोदय इसको काफी कड़ा किया गया है। अब 2 साल से 5 साल तक की इसमें सजा दी गई महोदय। एक सबसे महत्वपूर्ण जो लाया गया है कम्युनिटी सर्विस। तमाम जेलों में हमारे जो कैदी हैं, जो ज्यादातर गरीब घरों के होते हैं, छोटे छोटे अपराधों में बंद हैं, उनके पास जमानत का पैसा नहीं होता। और आज महोदय ये जो लाया गया है कम्युनिटी सर्विस, अब उनको सजा के तौर पर कम्युनिटी सर्विस का दंड के रूप में कहिए या न्याय के रूप में, अब वो कम्युनिटी सर्विस करेंगे। आप स्कूलों में मालीगिरी का करा लीजिए, चौकीदारी करा लीजिए, वो राज्य सरकारें डिफाइन करेंगी कम्युनिटी सर्विस। ये लाया गया। लूनाटिक शब्द था, एक बड़ा डेरिवेटरी वर्ड था, उसकी जगह पर मेंटल इलनेस लाया गया महोदय। और सबसे बड़ा महत्वपूर्ण महोदय, कि हमारे विरोधी कभी जब बात आती है भारत की सॉवरेनिटी, इंटीग्रिटी, इस चीज पर आती है, सिक्योरिटी पर आती है, जो सीधे टेररिज्म और तमाम चीजों से जुड़ी होती है, तो हमेशा ये इनका हाथ पीछे हो जाता है। और महोदय सुप्रीम कोर्ट का आदेश से वो खत्म हुआ, जिसको हम राजद्रोह कहते हैं, और ये इसमें व्यक्ति प्रधान होता था। और महोदय अब हम लाए हैं देशद्रोह। देश की इंटीग्रिटी, सॉवरेनिटी, सिक्योरिटी से कोई समझौता नहीं हो सकता महोदय। और इसके लिए मैं अपने गृह मंत्री और प्रधानमंत्री जी को मैं बधाई देना चाहूंगा। इसमें मृत्युदंड तक की व्यवस्था की गई है महोदय। ये कुछ चीजें थी सैलिएंट पॉइंट, जो मैंने भारतीय न्याय संहिता के बारे में बताया। और अब मैं बताना चाहूंगा जो भारतीय नागरिक सुरक्षा संहिता है, जिसको अंग्रेजों ने क्रिमिनल प्रोसीजर कोड का नाम दिया था महोदय। उसकी कितनी धाराएं बदली गई, कितनी जोड़ी गई, मैं पहले उसको बता चुका हूं। इसमें एक महत्वपूर्ण चीज जोड़ी गई महोदय। एक नागरिक को बड़ी दिक्कत होती है एफआईआर लिखाने की। लोग कहते हैं मेरी एफआईआर नहीं लिखी जा रही है, और कहीं डिस्प्यूट हो गया जुरिडिक्शन का, आप प्रदेशों की बात जानिए, 2 प्रदेशों के बीच की, इवन जिलों में, तो उसको दौड़ना पड़ता था वो एफआईआर कहां लिखाए महोदय। पहली बार आज इस नागरिक सुरक्षा संहिता में प्रोविजन किया गया 0 एफआईआर, घटना कहीं भी लिखा सकते हैं और 24 घंटे में वो एफआईआर संबंधित थाने पर पहुंच जाएगा और उसका इन्वेस्टिगेशन देगा। इससे महोदय, इससे बड़ी राहत क्या हो सकती है, जो पहली बार इस कॉन्सेप्ट को कानून में लाया गया महोदय। एफआईआर को इलेक्ट्रॉनिक तौर पर दर्ज करने का प्राविधान किया गया है। और महोदय एक अडल्ट्रेशन जो है, फूड, ड्रग, ये बहुत महत्वपूर्ण है। आज हम जो दूध पीते हैं या हम कोई सब्जी खाते हैं, हमें ये नहीं मालूम होता कि ये अडल्ट्रेटेड है कि नहीं है। लेकिन उसको बहुत कम महत्व दिया जाता था। उसमें मैक्सिमम सजा थी 6 महीने की। अब 6 महीने की मैक्सिमम है तो कोर्ट उसको महीने भर की दे दे, कुछ फाइन दे दे, लेकिन अब इसको कड़ा बनाया गया है और इसमें महोदय जो 6 महीने का मैक्सिमम था उसको मिनिमम कर दिया है, मिनिमम 6 मंथ, और उसके बाद उसका जो अपराध है उसके अनुसार बढ़ाया जा सकता है। जुर्माना 25,000 तक इसमें कर दिया गया महोदय। एक सबसे बड़ा होता है जो पुलिस पर आरोप लगता है, सर्च और सीजर, कि साहब ये ट्रांसपेरेंट नहीं है, पुलिस ने इतना दिखाया, अपने पास रख लिया। अब जितने भी महोदय सर्च और सीजर कुर्की होगा उस सब की वीडियोग्राफी का प्रोविजन किया गया है महोदय। ट्रांसपेरेंट है, कोई आदमी अब ये आरोप नहीं लगा सकता। तो ये ट्रांसपेरेंसी के लिए जो ये लाया गया वो बहुत बड़ा स्टेप है। उसके बाद महोदय एक सबसे बड़ा होता है फॉरेंसिक साइंस का इस्तेमाल। अभी हमारे यहाँ कन्विक्शन रेट बहुत कम है और जब तक पुलिस जाती है सीन डिस्टर्ब हो जाता है, हम वहां से फिंगरप्रिंट उठाते हैं और भेजते हैं, तब तक तमाम चीजें बदलाव हो जाता है। अब महोदय जहां 7 बरस से ज्यादा की सजा होगी वहां फॉरेंसिक टीम का जाना मस्ट है। ये इस कानून में प्रोविजन सभापति महोदय किया गया है और इसके लिए हर जिलों में फॉरेंसिक लैब की वैन चलेगी। इसके लिए 2000 करोड़ की व्यवस्था की गई है। सभापति महोदय, नेशनल फॉरेंसिक साइंस यूनिवर्सिटी है और 7 स्टेट यूनिवर्सिटीज खोली गई हैं, 2 ट्रेनिंग सेंटर हैं महोदय। इसमें 35,000 साइंटिस्ट और फॉरेंसिक एक्सपर्ट ट्रेंड होंगे और कुछ ही वर्षों में महोदय हम पूरे देश में फॉरेंसिक के एक्सपर्ट पहुंचा देंगे और वो वैन पहुंचेगी, जांच होगी और कोर्ट में जाएगा, डिजिटल तरीके से जाएगा और कन्विक्शन रेट हमारा जो लक्ष्य है, जो हमारे गृह मंत्री जी ने रखा है 90%, उसको हम जरूर प्राप्त करेंगे महोदय। दूसरा आता है महत्वपूर्ण केसेज में जांच डिप्टी एसपी या उससे उच्च अधिकारी को दी जा सकी है, इसका प्रोविजन किया। एक महत्वपूर्ण होता है इन्वेस्टिगेशन में डिले। अब एफआईआर कायम हुआ तो 90 दिन में चार्जशीट लगाना अनिवार्य किया गया है और यदि किसी कारण 90 दिन में चार्जशीट नहीं लगाई जाती तो कोर्ट के आदेश से उसमें 90 दिन और बढ़ाया जा सकता है, लेकिन 180 दिन में चार्जशीट लगना अनिवार्य है। सभापति महोदय, इसके अलावा जब पुलिस चार्जशीट भेजती थी कोर्ट में पड़ा हुआ है, चार्ज फ्रेम नहीं हो रहा है, लेकिन अब महोदय जब चार्जशीट चली गई तो कोर्ट के लिए अनिवार्य होगा 120 दिन में चार्ज फ्रेम करें और उसका ट्रायल शुरू। ट्रायल जब शुरू होता था तो ज्यादातर जो डिफेंस के वकील होते थे उनकी तबीयत खराब हो जाती थी महोदय। 2-2 दर्जन 3-3 दर्जन एडजमेंट लिए जाते थे और वो पीरियड ऐसा होता था जो दबंग होता था, माफिया होता था, वो जो है गवाह तोड़ लेता था, धमका लेता था, विन वॉर कर लेता था। और अब जो प्रोविजन आया है कि 2 से ज्यादा स्थगन आदेश एडजमेंट नहीं लिया जा सकता, इसलिए ट्रायल में तेजी आएगी और पीड़ित को न्याय मिलेगा। महोदय, कोर्ट्स में केस की सुनवाई खत्म हो गई, जजमेंट रिजर्व पड़ा हुआ है। अब जो प्रोविजन किया गया है अदालत के लिए, न्यायालय के लिए, कि जब सुनवाई खत्म हुई तो 30 दिन के अंदर जजमेंट देना होगा महोदय। इससे आप देखेंगे कि एक तो जो न्यायालय में मुकदमे का भार कम होगा, क्योंकि हम समरी ट्रायल लाए हैं, तमाम केसेस समरी ट्रायल में खत्म हो जाएंगे 40%। और अब जो हमारे न्यायालय हैं उन पर वो बोझ नहीं रहेगा और जो जघन्य केस हैं उस पर जो उनको समय दे सकेंगे उसका होगा। और एक जो अपेक्षा की गई और वो 100% सही होगी कि हम 3 साल में से ज्यादा कोई भी केस न्यायालय में पेंडिंग नहीं रहेगा महोदय और न्याय होगा। आज 20-20 साल से केसेस पड़े हैं महोदय, एक मैं केस जानूं, सब जानते होंगे, बेहमई केस। वो हुआ था वैलेंटाइन डे 14 फरवरी 1981। महोदय मैं बगल के जिले में एडिशनल एसपी था जानपुर में। उस केस में आज तक महोदय जजमेंट नहीं आया है। 38 मुलजिम थे, 38 में करीब 34 इनकाउंटर में मारे गए या मर गए, केवल 4 बचे हैं और आज तक जजमेंट नहीं आया है। और महोदय जो उसकी मेन अभियुक्त थी वो सांसद भी बन चुकी, उनकी हत्या भी हो चुकी, लेकिन 4 बचे हैं और जो मेन मान सिंह बचा है जिनका हस्बैंड था, आज तक नहीं हुआ। एक पार्टी ने माननीय बनाया उन्हें और महोदय न्यायालय से जो पुलिस की केस डायरी गायब कर दी गई। अब वहां पर फोटोकॉपी तो है, लेकिन जज साहब हिम्मत नहीं कर पा रहे हैं। तो आज 40 वर्ष से ऊपर समय हो गया महोदय। तो ये स्थिति आज जो नया कानून आ रहा है उसमें अब ये नहीं होगा। गवाहों की सुरक्षा का प्राविधान किया गया महोदय। दूसरा, हमारे थाने जो केस प्रॉपर्टी पकड़ी जाती थी, गाड़ी पकड़ी जाती थी, एक्सीडेंट में गाड़ी टूट गई तो हमारे थाने जंक यार्ड बन जाते थे महोदय, और उसके डिस्पोजल की सुविधा नहीं थी, क्योंकि जब तक कोर्ट में केस चल रहा है, अपील में है, तब तक उसका डिस्पोजल नहीं हो सकता महोदय। अब जो किया गया है कि वो जो प्रॉपर्टी है उसका वीडियोग्राफी होगा, डिजिटल, उससे उसको कोर्ट में दिया जाएगा और वो प्रॉपर्टी अब ऑक्शन हो सकती है, हमारे खजाने में पैसा आएगा और थाने जो हमारे हैं वो जो जंकयार्ड बन चुके थे इससे मुक्त होंगे महोदय। लोक सेवक के खिलाफ चार्जशीट, सीनियर अफसरों के खिलाफ मुकदमा कायम हुआ, चार्जशीट लगनी है, लेकिन गवर्नमेंट का सैंक्शन जरूरी है। जो जिनके संबंधित सरकारें होती थी तो वो सरकारें सैंक्शन नहीं देती थी महोदय, पड़ा हुआ आप लिखते रहिए। सीबीआई चार्जशीट स्तर पर पहुंच गई, राज्य सरकारें उसमें अनुमति नहीं दे रही हैं। अब किया गया है कि अगर 120 दिन में सैंक्शन नहीं मिलता तो मान लिया जाएगा इट इज ए डीम्ड सैंक्शन और उस भ्रष्ट लोक सेवक के खिलाफ चार्जशीट महोदय लगाई जाती। एक महत्वपूर्ण प्रश्न हमेशा कंट्रोवर्सी रही, हथकड़ी लगाना महोदय। मैं तो खुद पुलिस अधिकारी रहा हूं, आज तमाम होता है कि हथकड़ी ना लगाने के कारण मुलजिम एस्केप हो जाता है और पुलिस के जो जवान होते हैं उनके खिलाफ 224 आईपीसी का मुकदमा कायम होता था। अब महोदय इसमें हथकड़ी लगाने का प्रोविजन इसमें किया गया है, आर्थिक अपराधों को छोड़कर जो जघन्य केस के अपराधी हैं। ये सर मैं जल्दी से समाप्त कर रहा हूं महोदय। और प्रोक्लेम्ड ऑफेंडर, ये बड़ा महत्वपूर्ण है महोदय। बड़े बड़े अपराधी क्राइम किए और बैठे हैं, उनका क्योंकि यहाँ उपलब्ध नहीं है, उनका ट्रायल नहीं हो पाता था। अब महोदय ट्रायल इन एब्सेंसिया हो सकता है, उनको सजा दी सकती है, उनकी प्रॉपर्टीज अटैच की जा सकती है। तो ये महोदय जो प्रोविजन लाया गया है ये बहुत ही महत्वपूर्ण है। अब थोड़ा सा समय दे दीजिए, मैं साक्ष्य अधिनियम पर कुछ बोल दूं। तीसरा अधिनियम है महोदय भारतीय साक्ष्य अधिनियम 2023। इसमें जो है तमाम गुलामी के काल के आकार के शब्द थे। क्या थे? पार्लियामेंट ऑफ यूके, नोटिफिकेशन बाय क्राउन रिप्रेजेंटेटिव, एनी डोमेनियन, कॉलोनी, possession of Her Majesty or Privy Council, Her Majesty's government and possession of British Crown, all that जो कॉलोनियल वर्ड थे इसमें एविडेंस एक्ट में उस सबको निकाल दिया गया महोदय। ये गुलामी के चिन्ह जो थे ये समाप्त हो गए हैं। दूसरा महोदय सबसे महत्वपूर्ण है जो इलेक्ट्रॉनिक एविडेंस है। आज हर चीज में क्राइम होता है कहीं ना कहीं। टेलीफोन, सबसे पहले हम टेलीफोन की, मोबाइल की ही बात करते हैं कि वो मिल जाए तो उसको हम एनालाइज करके मुलजिम तक जितने लोग उसमें शामिल हैं पहुंच सकते हैं। उनको सबको दस्तावेज की श्रेणी में लाया गया महोदय। और साथ ही साथ कि जो हमको एविडेंस मिलेगा वो सेकेंडरी होगा, तो उसमें कोई घपला ना हो उसके लिए भी व्यवस्था की गई है। और ये किया गया है, उसका एक अधिकारी होगा और वो जो होगा उसको देखेगा, सर्टिफिकेट देगा, तब कोर्ट में उसमें मान्यता होगी। महोदय आपने समय दिया, बहुत बहुत धन्यवाद महोदय। आज ऐतिहासिक दिन है और हम सभी उस इतिहास के हिस्सा बन रहे हैं। और महोदय, मैं तो एक गरीब घर में पैदा हुआ था और आज उस गरीब घर के बच्चे को आज न्यायालय में इसमें इस महत्वपूर्ण ऐतिहासिक दिन पर बोलने का मौका दिया महोदय, और इसके लिए ये मेरे लाइफ का सबसे महत्वपूर्ण दिन है। उस दिन भी था मेरे जब मुझे चेयरमैन बनाया गया था होम अफेयर कमेटी का। इसलिए महोदय, मैं बहुत बहुत आपको धन्यवाद देता हूं इस बिल पर मौका दिया, और प्रधानमंत्री जी को और माननीय गृह मंत्री अमित शाह जी को मैं बहुत बहुत बधाई देता हूं। खासकर अमित शाह जी ने, जिन्होंने 4 साल इस बिल को बनवाने में 181 मीटिंग उन्होंने खुद अटेंड किया, मेहनत किया। पूरे देश के जितने विद्वान थे, सभी मुख्यमंत्रियों को, सभी एमपीज को, वाइस चांसलर को, सभी यूनिवर्सिटीज को, सबको इन्होंने पत्र लिखे, और पत्र लिखने के बाद तमाम उसके आए, उसके तो उनके कमेंट्स आए, उनके इनपुट आए, और उन सबको मिला करके आपने 4 साल में बिल तैयार किया और 11 अगस्त 2023 को पेश किया, और आज ये राज्यसभा से पास होकर महोदय कानून बन जाएगा। बहुत बहुत धन्यवाद। जय हिंद, जय भारत।
Message from Lok Sabha Secretary General.
Sir, with your kind permission, I rise to report that the Lok Sabha at its sitting held on 21st December 2023 has agreed without any amendment to the Chief Election Commissioner and other election commissioners' appointment, conditions of service and terms of office Bill 2023, which was passed by Rajya Sabha at its sitting held on 12th December 2023.
Shri Sujit Kumar.
धन्यवाद अध्यक्ष महोदय। महोदय, मैं अपने पार्टी बीजू जनता दल के तरफ से ये 3 ऐतिहासिक कानूनों के समर्थन में खड़ा हूं। महोदय, मेरी पार्टी बीजू जनता दल हमेशा कोई भी कानून जनहित में हो या देश हित में हो, सरकार के साथ हमेशा खड़ी रहती है, चाहे वो 370 धारा को हटाने की बात हो, चाहे ट्रिपल तलाक की बात हो, या चाहे ये 3 कानून हो। और व्यक्तिगत तौर से महोदय, मैं I applaud these 3 bills because these are in the interest of Mother India. They uphold the integrity, unity and sovereignty of our country. Hence, I personally support these 3 bills. और महोदय, मैं अपने आप को खुशनसीब मानता हूं क्योंकि ये बिल पे मुझे बोलने का मौका मिला है, क्योंकि मैं एक अधिवक्ता भी हूं और मैं स्थायी समिति का सदस्य भी हूं जिसको ये बिल्स रेफर किए गए थे, और जिसके चेयरमैन ब्रिजलाल जी थे, जिन्होंने अभी अपने अभिभाषण में विस्तृत रूप से बताया। और मैं धन्यवाद दूंगा गृह मंत्री जी का कि बहुत सारे प्रोविजंस, बहुत सारे सजेशंस जो समिति ने दिया था उसको इनकॉर्पोरेट किया गया इंग्लिश में। सर, Brijlal ji has already spoken and gone into details about the technical provisions for the bill. I will articulate why I support this bill, giving 5 reasons. Sir, first and foremost, sir, the essence of these 3 bills are justice, equality, and neutrality. Justice, equality, and neutrality. Sir, these are the 3 foundation pillars of our constitution. Hence, because of the constitutional norms, because we all believe in the constitution of the country, which Honorable Prime Minister said is the Bible of our nation, the Gita of our nation. Hence, sir, I support this bill because this is a tribute to the founding fathers of our constitution, Dr. Ambedkar, Sardar Patel ji. Sir, second reason why I support this bill is because this is a great step in moving away from the colonial hangover. Sir, there were 475 places in the three acts, IPC, CRPC, and Evidence Act, Indian Evidence Act. There were 475 mentions of colonial references: Her Majesty, Privy Council, Jury and Barrister, London Gazette. So, sir, at one stroke, these 3 bills are completely doing away with all the vestiges and signs of colonial hangover. Sir, secondly, sir, Indian Penal Code 1860, CRPC, Indian Evidence Act 1872, though they had Indians in their name, they have Indian in their name, but sir, there was nothing Indian about them. The soul was certainly not Indian. The names might have Indian in them, but the soul was of Great Britain. So, sir, because the soul was not Indian, there was no trace of Indian culture, Indian tradition, Indian values. So, sir, through these bills, हम लोग सर इसमें भारत की खुशबू को लाने की कोशिश की है सर। Sir, the criminal acts that we have, IPC, CRPC, Indian Evidence Act, they were meant to perpetuate the colonial rule. They were meant to subjugate the Indian subjects into slavery and brutality, sir. So they were never meant to give justice to Indians. They were never meant for the good of Indians. So, sir, these three bills, which will replace those three colonial legislations, will provide justice to our countrymen, will be for the betterment of our fellow citizens. Sir, in the IPC, CRPC, in IPC, you had, sir, offences against the state, offences against public servant, preceding, sir, heinous crimes like rape and murder. That was, sir, the need of the colonial masters, because they gave precedence to offences against them over offences against an Indian. But in this, sir, BNS, Bharat Nyaya Sanhita, offences against crime against women and children have been given precedence, particularly crime against women and children. Sir, Section 124A, sedition, has been done away with. सर, राजद्रोह को हटा के देशद्रोह को सर लाया गया है. ये बहुत बड़ा परिवर्तन है सर. सर, governments will come and go. Governments will come and go, sir, but nation will remain for eternity. Nation first. That has been the philosophy of removing sedition. And in place of sedition, sir, we have incorporated a clause which upholds the unity and integrity of our country. Sir, by removing sedition from our statute book 124A, sir, today we pay tribute to hundreds and thousands of our freedom fighters who went to jail, who were sent to gallows because of the misuse of 124A by the colonial rulers. Sir, the third reason why I support this bill is because, sir, this is a great example of modernization of our legal system. Sir, our criminal justice system was obsolete, archaic. We all know, sir. It was crying to be reformed. Sir, there was a desperate need to overhaul our laws, to modernize our legal framework, because, sir, the society has evolved. 1860, 1872, 160, 170 years old laws, sir. Society has evolved. Social values have evolved. Technology has become so prevalent. Sir, today we have technology in pretty much every walk of life, be it education, health, agriculture, but not in the legal fraternity, sir. So there was a need to bring in technology to modernize our legal framework, and these three bills have done that. Sir, already Bijlal has spoken about many of the provisions where technology will be incorporated. Sir, digitization of the criminal justice process. Sir, the definition of document has been expanded to include electronic digital records. Digital electronic records have been made primary evidence under the Bharatiya Sakshya Bill. Sir, now inquiry trial can be conducted digitally. Electronic recording of a statement by the police is also permissible, sir, during investigation. Sir, the provision of EFIR and zero FIR have also been incorporated, sir. Sir, women will be the biggest beneficiary of this. Sir, we all know that women find it very uncomfortable to go to a police station to register an FIR. That's the reality, sir. But now they can go for an EFIR. They don't have to go to the police station. They can file zero FIR. They can file FIR anywhere else, wherever they are comfortable filing an FIR, not necessarily in the police station under the jurisdiction of which the crime has been committed, and FIR can be filed. So, sir, this will eliminate the need to travel to the police station, particularly greatly aiding our women, sir. And, sir, the new laws also prioritizes the usage of forensic science in crime investigation. Sir, for any crime, for any offense where the punishment is over 7 years, it has now become mandatory for a forensic expert to be present at the scene of crime during the investigation. Sir, this integration of technology and digital forensic science, sir, will allow the police to, sir, get critical information and help in increasing our conviction rate. Today, sir, our conviction rate is one of the lowest in the world. And, sir, government has often spoken about increasing this conviction rate to about 90%. So, sir, I strongly feel that this bill will certainly help in increasing the conviction rate. Sir, videography is now made compulsory at the time of search and seizure of any property. Again, this will help in protecting the fundamental right of the citizen. Sir, organized crime, clause 111, petty organized crime, clause 112, great additions to the IPC, sir, to the BNS. Sir, terrorism Sir, previously I'm shocked to state that there was no mention of terrorism. Sir, we talk of zero tolerance towards terrorism. Sir, when we talk of zero tolerance towards terrorism, but we do not have a section in IPC where terrorism could be punished, how, sir, are we going to uh, tackle terrorism, particularly cross-border terrorism, when we are surrounded by a very, very hostile neighbor? Sir, crime against women and children have been given stringent punishment under this new provision. For gang rape, 20 years of imprisonment has been prescribed, and for gang rape of a minor, death penalty has been prescribed, sir. Sir, this will certainly deter heinous crime against our women and children. Sir, the fourth reason why I support this bill is because it will help in the timely dispensation of justice. Sir, we all know today our courts are pretty much choked up. We have close to 70,000 cases pending in the Supreme Court, close to 60 lakh cases pending on the High Court, over 4.23 crores cases pending in our trial court, district court, sir. Sir, it is often said, justice delayed is justice denied. Sir, there are numerous movies, movie dialogues, sir, on this aspect. I did not go into detail, sir. You have been one of the finest lawyers of the country, you understand. Sir, now this legal provisions will have strict timeline for the state, for the investigating agencies, and also for the judiciary. Sir, this is why I believe that this will result in timely dispensation of justice. Trial in absentia is another great addition. Sir, this will help in bringing the fugitives, particularly the economic offenders who commit crime in our country and then they abscond. They will be certainly deterred. And final reason, sir, why I support this bill is because of the reformative aspect instead of the punitive aspect. Sir, the name itself, it was called Indian Penal Code, but now it is the Bharat Nyaya Sanhita. So, sir, from punitive to justice. Sir, I would like to, refer to Swami Vivekananda, sir, who is one of the greatest gift to mankind from our land, one of the greatest philosophers that the world has ever seen. And he often spoke of the fact that each soul is potentially divine. Each soul is potentially divine. That was, sir, Swami Vivekananda's philosophy. Sir, this underscores the intrinsic value of every person. This underscores the reformative, the rehabilitative potential of every person. And this is what these three bills speak about, sir. Sir, community service. Instead of sending a person to jail for minor offenses, community service also has been prescribed as a form of punishment. This will, sir, not only decongest our prisons, but also bring in some kind of social reformation, some kind of social aspect to our criminal justice system. Great addition, sir. For the first time, community service has been prescribed as a form of punishment for petty offenses, and I greatly welcome this. Sir, I would like to talk of Section 309 of IPC, punishment for attempt to commit suicide. Sir, a person takes the extreme step of committing suicide only when she or he is so mentally depressed that she or he finds no hope in living, in surviving. And sir, when that person fails in committing that crime, meaning fails in committing suicide, we then go on to punish that person. So what kind of justice was this? I'm surprised that even after 75 years, this section was there in our IPC, in our statute book. Thankfully, I must really compliment the government, sir, that they have now done away with Section 309, attempt to commit suicide. This was already, sir, diluted through the Mental Health Care Act of 2017, but now it's also not there in our criminal statute book. Highly commendable, sir. Sir, I have a couple of suggestions, sir. Sir, one is that, sir, the Law Commission has time and again recommended that the ratio between judges and population in our country should be 50 per million. But today, the judges to population ratio in our country is only 19, which is one of the lowest in the world. So I request the government, ma'am, through you, that they should seriously look into it and increase the number of judges, particularly at the trial court, in the trial courts, and also increase the number of policemen. Today, the global standard is about 220, 225. Our prisons. Sopati Murmu also made an emotional appeal in this aspect while addressing the National Law Day celebration. And she lamented that many in India end up being in jail for years for the slightest of crimes, or even when wrongly framed. They have little recourse. This needs to be fixed. This is, Madam President. So I really urge the government, I strongly urge the government that they will look into this issue of UTPs, issue of under-trial prisoners crowding our prisons. Not only are they crowding our prisons, it's a violation of basic fundamental right. Every person has a right to be free unless proven guilty. So this is something which I would love the government to look into. And the third suggestion I have, ma'am, is regarding the multiple FIRs. Ma'am, recently we had many cases. We also had a recent case of Miss Nupur Sharma. She had to face, I'm not getting into the merit of what she said and whether there should have been multiple FIRs in her name, or there should have been an FIR on them. But the fact that she had to face multiple FIRs in different parts of the country, that itself is so problematic, ma'am. This is why I suggest that there should be provision in the statute book that there cannot be any provision of multiple FIR, because not only is it an unnecessary harassment of the accused, but also it delays the criminal justice system. And my last suggestion, ma'am, is regarding the gender neutrality. There have been a lot of positive aspects in the three bills in respect of making them gender neutral as opposed to the old ones. But now that 377 is no longer there in the statute book, and 375, which IPC 375, which is the offense of rape, is not gender neutral. So there is no way a person could be punished for raping a man. And we know, ma'am, that it happens. It happens in our prisons, it happens in our hostels, and it happens in other places. Men are routinely raped, but there is no provision in our statute book to punish for that rape of a man. We have thankfully, there are provisions relating to the kidnapping of children, trafficking. These have been made gender neutral in the BNS, but not the offense of rape. Law Commission in 2000 and the Justice Verma Commission in 2013 had also recommended that offense of rape should be gender neutral, but I'm sad that this has not been done in BNS. I hope this will be taken care of. Ma'am, I would like to finally talk briefly, while I'm on the subject of criminal justice system, I would like to briefly talk about the judicial overreach or the judicial encroaching on the turf of the parliament, which is so dangerous for our parliamentary democracy. Ma'am, separation of power is an essential feature of our constitution. Article 50 talks of separation of power. The three organs of the government have to work in their own respective domain. But, ma'am, this fine balance between judiciary and the legislature and the executive is being routinely, I must say routinely being eroded and trampled by the judiciary in the name of fundamental rights, in the name of separation, in the name of independence of judiciary. There is unnecessary interference time and again by the courts in administrative matters, ma'am. This is destroying the spirit of our constitution and is very, very dangerous for our democracy. Ma'am, the judiciary wants to reform every aspect of the government, but itself. It wants to reform every aspect of the government, but it doesn't want to reform itself. This is why we have such a large pendency of cases which the judiciary has not taken note of. Ma'am, the parliament and the state assemblies, they reflect the will of the people of India, the sovereign will of the people of India. And it is the duty, the mandate, and the responsibility of the parliament and the state assemblies to make laws. The judiciary, at best, can interpret those laws. But the judiciary has taken unto itself the task of making laws. So, ma'am, the classic example of the national judicial accountability Commission of 2000, the Act, NJSC Act of 2014. Unanimously, it was passed by both the houses of parliament. 2/3 of the states ratified it. 16 states, ma'am, ratified this act, but it was struck down by the Supreme Court of India because the Supreme Court deemed that this was interference into the judicial appointment, thereby violating the basic checks of the Constitution, which is independence of judiciary. Ma'am, and here I would like to quote former Finance Minister, late Sri Arun Jaitley, who had called this the tyranny of the unelected. He had called, and in his words, I quote, if the elected are undermined, democracy itself would be in danger. So, ma'am, I'll end by supporting the three bills. I think they are extremely timely. They are in the interest of the nation. And also, I have already stated my concern about judicial overreach, judicial encroachment into the working of the executive and the legislature. And I hope that good sense will prevail and that the separation of power, which is there in Article 50 of the Constitution, will be respected by all the three organs of the government, particularly by the judiciary. Thank you.
Sri S.K. Niranjan Reddy.
Thank you, ma'am. Ma'am, I feel privileged that on this momentous occasion when we are revising the entire criminal law administration, I get to speak on behalf of my party. I am rising to support the bill for a few reasons, which I will spell out one after the other. Madam, my first reason for our party supporting the bill is the clear intent that the government wants to show for the purpose of changing and improving the criminal law administrative system. So when I say improve, there has been some criticism that the laws are mostly similar to the outgoing legislations in many areas. There has also been a criticism that there has been a cut and paste job. I think this criticism is misplaced. I feel, madam, that when these old laws are being replaced, some of the provisions have been interpreted over a period of time. The courts have now given specific meaning to certain expressions. They have culled out specific procedures that need to be followed, also built in certain safety. So if those provisions are reincorporated when a new law is made, it will settle a lot of these provisions because some new provisions dealing with new offenses are being introduced separately under the penal code. There are some new procedures being brought in under the BNSS, and there are some new Evidence Act provisions which are brought in under the new Act. But when a lot of the provisions which are otherwise working well, if they are retained in the new provisions that are made, I do not agree with the criticism that this should not have been repeated. There should have been a whole-scale change. The other criticism is that the old acts could have been amended if only the government wanted to introduce a few new provisions or few new offenses or new procedures. Now, this also, ma'am, I do not agree completely, because what would happen is if someone is making large-scale changes to existing laws, by the very numbering of the provisions, the amendments will make the act unwieldy. Like in the Income Tax Act, when amendments were made where the amendments would start with a particular section. It will start with 15A, it will go to 15ZA, it will go to 15ZE. So if we are making certain large-scale changes to the law, I commend the government's approach in bringing in a new law while retaining the essence of the old law wherever there is no difficulty. Ma'am, having said this, I think the revamp of the criminal justice administration is a journey. It is going to be arduous, but it needs to be earnest. I would want to compliment the government on starting this journey well. It has not stood on a principle or ego, because when these laws were introduced, in the first instance, madam, what is redeeming for me personally is that the government agreed to refer the matter to a joint parliamentary committee, which means the government was willing to look at suggestions. The joint parliamentary committee made certain recommendations. The government, in my view, accepted the correct recommendations. One of the recommendations of the parliamentary committee was contrary to the Supreme Court judgment. The government was cautious. It did not accept that recommendation because it understood that the law has been interpreted in a particular manner. So the provision, one of the recommendations was not accepted. Now, not only that, when the bill was introduced in the other house yesterday, the government made two further changes because the government received a proposal from the medical practitioners that some of these provisions may affect the medical practitioners without an intention. So the government is exhibiting a keenness where it wants to keep improving. Now that is a great position to start the revamp of a law because, as I said, Madam, the journey will have to be humble, it will have to be earnest, it will have to be by people who are not standing on ego. And I'm very glad that this government has shown an openness and willingness for the purpose of making further changes. Madam, I believe that the old method of making laws has now fundamentally undergone a shift. Earlier, society would move at a very slow pace. So if a law was to be made, the law would hold good for 20 years, 30 years. But in the current situation where developments happen so very fast, the approach may need to be one where the government may have to come up with many iterations of the law. So if this is the first step in bringing in the law, as so long as the government is alive to any evolving developments and is making changes accordingly, then, Madam, I think we would be having a first-rate law which the government is proposing to start, and it has started on a good note. Just for instance, to give an example, from the time this act was originally proposed to that bill being discussed before the Honorable Parliament, the government was not looking at a situation of a deep fake. Now, deep fake, even under the current amended law, would have to come possibly within the meaning of forgery only. There is no separate offense for deep fake. Luckily, we have a provision under the income tax, the IT Act and the rules, which make adequate provision for punishing people who are resorting to deep fakes. But the penal law, while this in my view would also be a penal offense, the penal offense is being addressed by virtue of the IT Act being capable of roping in such a mischief. So some of these new developments that may happen would need to be incorporated into our law from time to time. For instance, Madam, I also find that while we have taken care to bring in snatching of mobile phones or movables as an offense, we would still have to go back to the IT Act for the purpose of a data theft. Someone may not steal the mobile, but someone may actually be stealing the entire data from the mobile. Now, this may possibly come within the meaning of theft, which is very broadly defined under the old IPC and also under the new enactment. But there is no separate offense which deals with data theft. Now, as we go forward, there may be further developments that may happen where the law may have to be amended for the purpose of incorporating this. So, ma'am, I have a suggestion for the government. In the insolvency regime, we have a permanent committee which is called the Insolvency Law Committee. The law committee constantly looks at the developments in the field, it looks at development in the courts, and it constantly keeps making recommendations to the government that if a particular provision is introduced or if a particular explanation is added, it may clarify the position. And the government has been making these changes in the insolvency and bankruptcy code from time to time. Now that, Madam, deals with a very simple law in the relative context of the criminal administrative laws that we are looking at. And in that narrow space, that law has been very throbbing and has been alert to the needs of the society because of the Insolvency Law Committee being a permanent body that continues to make recommendations. So the recommendation, ma'am, I have for the Honorable Home Ministry is, the Honorable Home Ministry may consider, the government may consider having a permanent committee which could be headed by people who are experts in these areas, who would also get a feedback from the stakeholders, from the lawyers, from the judges, from the litigants, and then see how some courts are interpreting some of these provisions, because some of the interpretations may go contrary to the spirit with which the law has been made. So a small addition, small alteration, a small explanation may make a huge difference. So, Madam, this is one of my suggestions for the government, because this would make the law nimble, agile, and it will be very quick to react to whatever is needed of the society. Madam, the next point that I wish to make is a lot of new provisions that have been made were previously not covered. So the government is moving in the step of identifying some of the mischiefs which have been left out, where the government wants to arrest them, and they have incorporated a lot of things like organized crime, petty organized crime, terror has been defined. We have now an offense relating to endangering of unity, integrity, and sovereignty of the country after repealing the sedition laws. What I find, Madam, is that while we are making provision for dealing with offenses like this, the acts possibly at this point fall a little short of defining these terms and confining the meaning of these terms. Now, what has happened, Madam, is when criminal laws use expressions that are very wide, the courts have held consistently, this is courts all over the world, including the Honorable Supreme Court in India, have taken a view that if the expression is not clearly defined, it may start affecting persons and citizens who are not originally intended to be captured within the provision of that mischief. This makes the law excessively broad. It may then become vague, and it may therefore be struck down. So we have had one provision of the IT Act being struck down on this theory. I fear that some of these provisions are going to be challenged in court, and therefore it may require, as I say, a further iteration. It may require at some point of time the Parliament to step back in and give a clear definition so that these expressions are confined to the area that they are intended for. This is again a suggestion so that we don't wait for many years to pass and for a court to eventually define how this term must be understood. Because the entire area of defining what the term will mean is essentially that of the Parliament. And I think that is a right that we need to exercise rather than leave it to the court to interpret because of a gap in legislation. I am not at this point, Madam, suggesting that there are gaps that cannot be filled. I am only saying that the law can be improved with further iterations after hearing the stakeholders. Madam, then I move on to the next point. Another reason why we support the bill is the idea to quicken the criminal justice process system, the courts, and the manner in which an FIR will be lodged, a final report will be filed, the additional time that will be granted. All of this is good. The idea is noble, but it comes with a set of challenges. Madam, I would want to apprise the government that this is akin to the government wanting to have a very fast train, but the rails, the infrastructure is creaking. Madam, I appear in courts regularly when I am not here, and I have heard judges complain, including in national company law appellate tribunals, NCLTs, commercial courts, and other regular courts, that the judges are working in most subhuman conditions because they have no assistants, they do not have a stenographer. Judges are writing 80 pages to 120 pages by hand because the judgment will have to be delivered under the CPC within 30 days after the matter is reserved. Now, we have made a provision that a judgment will need to be delivered within 45 days, but I have serious doubts whether the infrastructure would enable the coming into effect of this clear, noble intention of the government. Madam, I also have a suggestion here. The suggestion is the central government will face a difficulty because the courts are a state domain. It is the states that will have to make provision for having adequate infrastructure. Center will not be able to sit on the state's head, and we sitting in the Council of States would not wish that the center should impose more than necessary. Now, if that is so, one of the ways the central government could consider ensuring that the intent that it has to have a first-rate criminal justice administration in the country is given effect to, without the states falling behind on providing infrastructure, possibly would be by providing for certain incentives like the Finance Commission does when states meet certain targets, be it in the power sector, be it in the educational sector, or solid waste management. Whichever states ensure that they are doing this, the Finance Commission is granting a higher share to the states. So if the legal reforms are also going to be included, specifically with reference to the criminal law justice infrastructure, then this act and the intent that it seeks to achieve can be easily accomplished. Otherwise, this might remain on paper. Like, madam, we all know the Representations of People's Act says that any election appeal in the High Court must be decided in 6 months. The law makes that provision, but we see that it rarely ever happens. Lucky are those legislators whose cases are decided before the person who won completes his term. Election petitions are now stretching for 4 years, 4.5 years. So while we may make a provision that a judgment must be delivered within 45 days, I am foreseeing some difficulties on the operational side because of the infrastructural deficiencies. So that may need to be attended to give complete effect to this law. Madam, then I have a suggestion to make with regard to the forensics. The provision of forensics that has been included, clause 176(3) of BNSS, is a very important provision. The government has also taken a very practical view. The government notes that it may not be possible to operationalize this forensic study being conducted unless an adequate infrastructure is built up. So the provision says that it will come into effect from a date to be notified by the state government within 5 years. Now, in this 5 years, the forensic infrastructure may need to come in. But one lacuna I find, and this may have to be addressed separately, not through the criminal justice system, is that the forensic science and forensic study in India does not have any regulator like the medical institutions or any other institutions. So a regulatory standard may need to be set up. An accreditation which will recognize may have to be provided. So my suggestion, madam, would be that the government make an appropriate provision for ensuring that the forensic framework is put into place. Sir, there is one other area that the government may have to consider, and the IT Ministry of the central government has doing a fantastic job in this. For the purpose of criminal investigation, we now enable the collection of biometric data by the investigating agency and by the court. Supreme Court says this is permissible. So there is no problem about the legality of the collection of some of this data. But the issue would be, where would this data be stored? How safe would this data be with the police and with the courts? How would the issues of privacy be covered? So these are some aspects that may need to be considered once these provisions kick in and they start operating from whatever date is notified by the state government. Sir, I then move on to certain aspects because we're dealing with a set of three different laws. I'm just going in a seamless manner from one act to another in relation to the criminal justice machinery. Sir, the concept of fair trial and the right of an accused. So when I say accused, I am not speaking about a person who is convicted or is guilty. I am speaking, sir, of a person who is accused of a crime, and our law proceeds on the assumption that every accused will be deemed to be innocent until he is proven guilty. So a person facing a charge who is an accused starts off with this presumption in his favor. We have had a very famous saying by one Russian writer, Fyodor Dostoevsky, who said, the mark of the development of a civilization is not from the way it deals with the people who have achieved well in the society. It is in the way it deals with the criminals of the society. Sir, with these two philosophies in mind, I have three quick suggestions. Sir, on the aspect of bail, I find, sir, that a majority of the old provisions have been carried over. It is salutary because the Supreme Court has interpreted these provisions to say that bail is the rule, while jail is the exception. But what happens, sir, is because our justice system was not very good. We have noticed a tendency over a period of time that courts are hesitant to grant bails in any matter where it thinks the accusation is grave, because several of these matters were resulting in acquittals because of witnesses turning hostile or the evidence not being properly placed before the court. Sir, once the changes are made, once we bring in forensics, once we have a better administrative system, we should slowly now start moving towards the developed countries where the criminal justice system clearly adheres to the belief that a person will be released on bail once he provides adequate security and if he is not interfering with the criminal trial, and his punishment will start after he is convicted by the court, not by putting him in jail and not granting him bail even before he is found to be guilty. Because, sir, in many cases we see if person is in jail for 6 months or 1 year and eventually it is found that he is actually acquitted, then the civil liberty can never be brought back.
Please conclude, Niranjan Reddy.
Sir, I have...
You have 9 minutes, you have spoken more.
Very well, sir. I'll try to finish as quickly as I can. Sir, while the bail has been liberalized, sir, there's one area that the government may have to consider. Sir, clause 479 in subclause 2 says that the benefit that the government wants to give of half the term being already spent in jail and 1/3 if it is not punishable with life or death, the person is entitled to be granted bail. 479(3) says the above provision will not be applicable if the person is guilty of more than one offense or is involved in more than one case. Sir, even if a person is accused of only one offense, many times we see, sir, that in the FIR they list out 4 or 5 offenses. So even a first-time offender, in the first FIR registered against him, will have more than one offense mentioned against his name, which will deny him the benefit of the bail that is provided under 479(2) of the BNSS. Sir, the third of the issues relating to the rights of accused is in relation to handcuffs. While clause 43(3) specifies that it will be done only in some serious cases, the Supreme Court has clarified that this is ordinarily treated to be inhuman. It must not be resorted to except in exceptional cases. Sir, I would want the government to lay down clear guidelines. It is not that whoever is accused of that variety of offenses need to be brought to the court in handcuffs. Sir, I have been in courts, in criminal courts. Sometimes when there is a grave offense and an offender is brought before the court, it is quite scary. Sometimes it gives us confidence when we see if that person is handcuffed, but this would be extremely rare cases where that kind of protection may need to be granted. So the government may have to come up, sir, with some guidelines in the cases where handcuffing will be permitted. Sir, the provisions now introduce the salutary feature of community service. Just 2 quick points. Sir, what will qualify as a community service? The types of community service are not specified. Now, this would leave it to the discretion of the magistrate. The magistrate will decide what will be community service. Is it sweeping the road? Is it manning a public duty at a traffic light? Or is it something else? So the legislature may have to step in. The parliament may have to come in for the purpose of indicating what are the types of community service that can be imposed by the court. The discretion will be with the court to impose which of the appropriate punishments. Also, sir, if the punishment is to be community service, the Act does not make a provision as to the length for which community service needs to be imposed. So if someone is guilty of theft of less than 5,000, it cannot be that he will be asked to undergo community service for 3 years. That will be worse than him facing punishment for that offense, which may be very small. Sir, then I have 2-3 other suggestions for making this even more workable. So we find that the Supreme Court of India is inundated with bail petitions, anticipatory bail petitions, and quash petitions, either grant or someone challenging the non-grant of a quash order. So this is happening because the old CRPC provided that all these bails, anticipatory bails, and quash petitions will be heard by a single judge of the High Court. There is no intra-court appeal provided under CRPC. So in the writ jurisdiction or on the civil side, there are a few appellate provisions which say that the appeal would lie from a single judge of the High Court to a division bench. So if in CRPC we bring in the new law, if we are able to bring a provision which will say that there will be an intra-court appeal in relation to bails and quash petitions, almost 80 to 90% of the people will get their justice in the division bench. Either they win or they lose. Very few cases will come up to Supreme Court. It will not clog the Supreme Court. Otherwise, Supreme Court is now left with dealing a lot of these matters, and it is not able to focus, sir, on the more serious and important issues. My friend, sir, Mr. Honorable Member Sujit Kumar had spoken about multiple FIRs. Sir, I find that we still will be having the same problem, that for one particular incident, multiple FIRs can be filed in multiple jurisdictions. We have not made a provision, sir, which says that if an FIR relating to that particular offense, I'll take only 2 more minutes, sir. If an FIR relating to the same offense is already registered, and if that is brought to the notice of the second registering police station, the police station must cease any further action. This provision is missing, sir. This may, again, as I mentioned in the earlier part of my address, if there are going to be repeated iterations, and that will be the way we will keep improving, some of these things can be addressed. Sir, also I noticed in clause 173, when an FIR is to be registered, the government wanted to ensure that the non-guilty people are not harassed. So clause 173(3) says that a particular police officer may take 14 days for the purpose of conducting a preliminary inquiry. But strangely, sir, that is only fixed for offenses above 3 years and below 7 years. So if it's an offense below 3 years, there is no provision today for conducting a preliminary inquiry. Sir, also we need to consider whether this clause 173(3) providing for preliminary inquiry should be for all such offenses, because it may mean that FIR is not registered for 14 days at a go. So the last of my suggestions. Sir,
Please conclude.
Clause 1, yes, sir, this is the last of my submission, sir. Clause 1 of each of the bills, sir, nomenclatures the act as BNS, BNSS, and BSA. Sir, I am using these abbreviations because I am not comfortable with the language. Sir, coming from Hyderabad, I can speak a bit of Hindi, but even I am not comfortable with this language, sir. Sir, the Constitution provides that the acts and the text of the act, which includes the name of the act in clause 1, ought to be in English. Sir, I respect that possibly we are trying to move away from a colonial hangover and a past. We want to signal a clear sign that this is our own homebred, our own cultured law. So this can be easily achieved without affecting the sanctity of the constitutional provision by saying that this will be called so-and-so in English, and also called so-and-so.
Okay.
So the two names, if they are mentioned, sir, what may happen is, in any event, the language of the court will be the language that the courts are using. The act becomes much more easier, sir. After spending so much time, sir, I have had this request from a lot of my lawyer friends who keep requesting that when I get to speak on this bill, I must make a request to the government to please include both the English and Hindi titles for this act, so that the act will be easily operational.
Okay.
Sir, I thank you for the opportunity. And I conclude by saying that my party entirely endorses the approach. We want to go along with the government and keep improving the bill. My suggestions are constructive. Sir, I would request the Honorable Home Minister to consider these suggestions. We support the bill fully, sir.
Thank you. Shri Kartikeya Sharma.
Thank you, Vice Chairman, sir, for allowing me to speak on this historic piece of legislation. I stand to speak in support of the bill. Sir, in the year 1834, the first Indian Law Commission was constituted under the chairmanship of Lord Macaulay, which gave birth to the Indian Penal Code in 1860. The Indian Evidence Act was enacted in the year 1872 with a view to consolidate the law relating to evidence. The Code of Criminal Procedure 1973 regulates the procedure for arrest, investigation, inquiry, and trial of offences under the Indian Penal Code and under any other law governing criminal offences. So these key provisions, which form the basis of the justice delivery system in India, have been antiquated and are age-old. When the British came to India, the original and the only purpose was colonization of the mind, since they believed that if the mind was colonized, they will not lead long-standing armies to colonize the natives. According to the British historian Elizabeth Kolosky, the main idea was that the British felt that the natives and the colonials needed different set of laws under which they were governed, as they felt the natives was incapable of appreciating the rule of law and hence needed stringent laws to be governed. That explains the idea behind the criminal tribes and the Thuggy Acts, which were based on the concept of hereditary criminality, which the British believed was inherent in the natives. Present laws as they stand reeks of colonial hangover. Sir, it still reminds us of the times when the British were ruling us, and they continue to rule us through these acts, written by them for them. These acts were formulated at a time when the population of the country was about 20 crores, and the population today is 7 times as compared to that. The previous acts were designed to serve the crown and its officers at the cost of the Indian society and resources. The acts were not only exploratory in nature, but far, far away from any kind of justice. It was a result of these inefficiencies that the criminal justice system ended up creating an atmosphere of distrust in the minds of the citizens, who remain largely apprehensive of finding any justice after suffering. So due to the changing nature of the society, its attributes, its elements, the laws have become obsolete and fall short in encompassing the overall picture of society and the needs of the prevailing system of the justice at large. A need was thus felt for a long time to overhaul this mechanism, make it more contemporary and inclusive of the existing constructs. So the new proposed laws reflect of the government's intention to align the legal system with the 21st century, emphasizing citizen-centric legal structures, digital transformation, and a focus on the justice rather than the punishment. So the context in which these acts have been introduced is very, very important. And while discussing these, we should not miss the wood for the trees. The intent is to create an ecosystem of justice delivery which is not procedural oriented, but justice centric. Sir, I would like to quote a share from Dushyant Kumar, which sums up this entire scenario in a very good way to begin my speech. कैसे मंजर सामने आने लगे हैं,